Yes.
I'd like to take your lordships to Snook.
Yes, I think you were.
Volume 20, Lords, tab 1.
Yes.
In fact, it's pretty complicated, and
But it's really the dictum on what is a sham.
absolutely, Lord. I said I'd show your lordship the references to estoppel as well. Lord Justice Russell, first of all, page 3848 of the bundle. The plaintiff's case for denying the right of the defendants to retake the car under the hire purchase agreement is threefold. The plaintiff, I should say, was the sort of owner and driver of the car. First, he says the defendants are not shown to have acquired title to the car. Second, he says the whole transaction was a dressed-up arrangement for a loan on the security of the car to avoid the bills of sale acts. Third, he says the hire purchase agreement was illegal and void because no actual payment of the sum stated was made. And then, first of all, on the first point, letter just above letter G, how can it be now open to the plaintiff after signing the documents which are referred to assert he became owner of the car and he's remained such? One only has to look at the matter from the defendant's point of view, defendants being, as the judge held, innocent and ignorant of any irregularities, to see it would be quite wrong to allow the plaintiff to take this title point. He's stopped by his own conduct from denying the defendant's title to the car. Then the plaintiff's second contention is that
well, I mean, that's a completely different case from the present, isn't it? That's where one party is innocent and ignorant, and
that's not this sort of
estoppel by convention, it's estoppel by reliance.
It's not this sort of estoppel.
No.
But then he says that the substance of the transaction was the borrowing of money by the plaintiff on the security of the car. Defendants can't rely on the hire purchase agreements because of the provisions of the Bills of Sale Act. So it would have been an unregistered bill of sale. And then he refers to some facts which militate against that, and then says, between C and D, to enable the court to hold that a transaction was intended to mask a loan, it must find that both parties to the transaction so intended. The latter case, Stoneleigh Finance and Phillips, is authority of the proposition. Even it's correct that the substance of the whole arrangement, as between the plaintiff and the other defendant, was to dress up a loan on security. That intention on the part of the other defendant can't be imputed to the innocent defendants, etc. Now, Lord Justice Diplock, page 801, between letters C and D, my sympathy, like that of Lord Denning, is for the plaintiff. My judgment, like that of Lord Justice Russell, must be for the defendants. And the way he describes the issues in that paragraph, between D and E, he says it ought not to happen to him for three reasons. One, the defendants never acquired title to the car. Two, he, the plaintiff, and Auto Finance, at any rate, intended the transaction to be a sham in order to mask a loan of £300 on the security of the car. And then there's a third point. Then letter G at the break, as regards transfer of the title, etc. He makes some preliminary points, and then over the page, just before B, in any event, I agree with Lord Justice Russell. He's stopped by his conduct from denying the defendant's title to the car. As the defendants were unaware that he intended a sham, it would be a travesty of justice if he were not. And in view of the terms in which his claim is pleaded, I don't think the defendants are debarred from relying, if it be necessary, on this estoppel, though it's not expressly pleaded as such in the defence.
It's all the same point, isn't it? It's the next paragraph deals with no sham because one of the parties didn't know that the other party's intention was it shouldn't bind.
That's right.
Yes.
It's necessary to consider what, if any, legal concept is involved in the use of this popular and pejorative word. I apprehend that if it has any meaning in law, it means acts done or documents executed by the parties to the sham, which were intended by them to give to third parties or to the court the appearance of creating, between the parties who enter into the sham, legal rights and obligations different from the actual legal rights and obligations, if any, which the parties intend to create. So if the transaction of the 4th of October 2011 was to be a sham, was correctly described as a sham as defined by Lord Justice Diplock, it would mean that the transfer, bought and sold notes and the other documents, including the declaration of the chairman's report 6 weeks later, were intended by Mr. and Madame Chen to give to some third parties or to the court the appearance of creating between them legal rights and obligations different from the actual legal rights and obligations of any which the parties intend to create. So if the documents correctly understood evince a transfer by Mr. to Madame Chen outright, including not just the legal title but the equitable title, if contrary to her primary but unsuccessful case, it was in him. There would be a sham if the two of them intended actually that Mr. should retain the equitable title, but that they had entered into these documents in order to present a different story.
The documents themselves don't deal with. The documents themselves don't deal with equitable title, except perhaps the board minute. They just deal with legal title.
Well, no. May I remind your Lordship of something that was said by Lord Brown Wilkinson in the Westdeutsche case,
yes, well,
which is that
retained.
It's a mistake. That you don't transfer legal and equitable title separately. You transfer the whole ownership.
Well, that's true, but you may transfer it subject to a separate disposition of the equitable interest. It actually amounts to much the same thing. You certainly don't do that by implication, but the intention that the documents should not create the rights and obligations which they give the appearance of creating has to be, as I understand it, agreed between the parties.
Yes.
On the same principles as one would deduce an agreement of a contract, the contract itself. In other words, it has to be overt by words or conduct.
Yes. And it's used as a pejorative term, as Lord Justice Diplock says, in cases where that is done to give a false impression to third parties or to the court in some proceedings which may take place.
So your point is quite simple, that even if Mr. had the intention of creating a sham, Mrs. Chen did not, because she was expecting to get complete title, and you say got it.
Yes.
Yes.
And that expectation of hers isn't, as it were, nullified by her alleged belief, which the judge rejected, that it had been in hers all the time. I mean, what was quite clear on any view was that she wanted and expected and regarded herself as having acquired, as being the equitable owner from that point on.
So, on that basis, surely she didn't expect the transfer documents to produce anything. I mean, if the position is that she knew perfectly well she wasn't the equitable owner, then a question arises as to whether one simply treats the documents as indicating on the face of it a transfer of full ownership, or whether both parties didn't know perfectly well that they were intended to deceive some third party.
But, yes, but that
I mean, and you point out that they may have been intended to deceive a third party by transferring full ownership, and that's not deceit anymore, that's actually
that's what happened.
doing it effectively, but that's a different matter. If neither of them intended actually to pass the beneficial interest, then if that were shown, that would undermine the documents, wouldn't it?
Yeah.
They would be shams.
But unless Mr. Story is believed, there's no evidence of that at all. I mean, there was certainly no documentary evidence in support of his story after the Katai Strip project had collapsed.
I thought you, at some point, you might show it us, but you put at some point to Mr. Nung that he may have been interested in transferring title because of his creditors. And that, of course, leads to a question. Was he simply pretending to have transferred the beneficial interest, or was he, in fact, doing the full exercise of transferring the whole title, which would take it outside the possession of the reach of the creditors in law?
And
But
your
at some
lordships,
point you put that to Mr. Nung, didn't you?
and your lordships remember that in our case, we have referred to what was said by Lord Justice Millett on that very point in Tribe and Tribe,
Yes, no, I've got that. Yes.
when he said if you're transferring property to save it from your creditors, you have to transfer it outright.
Well,
That may or may not succeed under the bankruptcy provisions or Insolvency Act provisions. If a sufficient interval hasn't passed, the trustee can get it back.
depends how trusting you are of the person to whom you're transferring it. If you trust them enough, you may be able to prepared to part with beneficial interests as well as on the basis that they're your other half, effectively. I think that's your case. If you don't trust them, then presumably you impose an equitable reverting interest, or retain one.
These parties had been in what Mr. himself described in his pleading a de facto marriage for 20 years. They had 2 children. We've acknowledged in a footnote that he said after they'd broken up they weren't his, but they'd been treated as their children. They were living with their children. Mr. himself, in his witness statement, said that he had suggested some years earlier that the Madame Chen's children by her first marriage should use his name, which indeed they do. So they were in a very close relationship and a trusting relationship. She made a will in his favour of the shares in January 2012.
Well, that's a factor you rely on, isn't it? That's a factor you rely on.
Yes.
Yeah.
The whole thing fell apart in February 2012 when Madame Chen, on her account, says that she discovered that Mr. was having an affair with the personal assistant whom she had retained for him. And, I mean, this was quite, had to be dealt with quite tactfully in the cross-examination at the hearing, because the lady in question was in court throughout with Mr. and in Madame Chen's oral evidence, there were on at least on one occasion, outbursts on her part in connection with that. I mean, there was clearly a major breakdown of their relationship in February 2012, and everything changed. She changed her will, and so forth. But what didn't happen after that is that Mr. Did not, having separated, their evidence was they never spoke to one another again after February 2012. What didn't happen, Mr. solicitors wrote to Madame Chen saying, could they have the shares back? He never asked for the shares back. And he was still saying in July 2012 to the, as it were, financial, the gentleman called Kern Gore, which means elder brother Kern, who had been running the cash flow of the hotel and the casino since the very beginning, since it was originally purchased. He wrote to him saying, Brother Kern, the hotel is nothing to do with me anymore.
What's the reference to that?
I've made that point in a number of different contexts. But we'll have to see if my learned friend seeks to advance a sham argument. I'm not going to object to it on the basis that it hasn't been pleaded, if he does, but we shall say that in the light of the legal understanding of the term and the requirements for establishing it, if you need to, it can't be done. My Lords, before I move on to the jurisdiction issues,
Yes.
which, as I understand it, I've got until 3 o'clock?
I think although that's what you've agreed, I think we'd rather have Mr. Parker on the substantive case and turn to the jurisdiction issue at the end.
Very well.
Unless that puts you or Mr. Parker in some difficulties.
No, not at all, not at all. I'm ready to deal with the jurisdiction
Of course.
points, but if it would be more convenient for your Lordship
I think so.
to hear Mr. Parker.
They are quite distinct issues and
Absolutely
better
fine.
to hear them all together, I think.
Absolutely fine. Lord, I'm not clear whether I've got until 3 o'clock or some little after 3, or
Basically, if you...
now,
if you better keep some time in the bank for the jurisdiction issue.
yeah. Well,
You should keep-
tomorrow.
Yes, we'll deal with the jurisdiction issue, I expect, tomorrow, yeah.
Yes, it would take me about half an hour.
That's very helpful, thank you.
But, Lord, I do need to deal with the second counter notice in the Court of Appeal. Mm-hmm. That was the additional evidence which we sought to rely on in the Court of Appeal, and the application to the board, which is not in the bundle because the other side wanted it in a separate bundle, perhaps so that they could ask your Lordships not even to look at it. But I ought to deal with it unless there's some objection to that before I sit down. But those two matters are of the same nature. In the Court of Appeal, by our second counter notice, we sought to rely on a pleading in Macau proceedings, which Mr. had filed in 2014, and which explained the transfer of the shares on the basis that it was intended to forestall his creditors. And we asked, that was evident, that was entirely within the relevant principles for adducing further evidence on appeal. It was evidence which had only come into being after the trial. We said it was not decisive, but important, and that we had applied to adduce it as soon as we could. And the Court of Appeal rejected that in the most perfunctory way. If I can just show it.
It was on the second ground. They didn't think it made much difference, wasn't that? They accepted the first and third grounds of Ladd and Marshall, but not the second. Yes.
It wasn't important.
It wasn't important.
It made a difference to the judge. And we say that what they missed was that
might have made a difference to them.
it was meant to make a difference to them,
Yes.
and that's why we referred to the.
Yes, it's a bit odd if you can't refer to extra evidence because you won below, but you're going to be reversed.
That's why we referred to the very interesting, historically, Admiralty case, which wasn't just to
No, but it must be.
use my.
No, it must be right that if the judge is going to be reversed on the facts, you're in the same position as if.
Sorry, Lord?
It must be right that if the judge is going to be reversed on the facts by the Court of Appeal, the person who's going to lose in the Court of Appeal can't have any worse rights than the person who lost below
Yes.
on the facts. Ladd and Marshall must apply equally.
Yes, we deal with it in our case at paras 153 following. And the point I've just made is that 159, the Court of Appeal dismissed the application on the ground that the second condition in Ladd and Marshall wasn't satisfied because it does confirm the suggestion put to Mr. that his financial difficulties were the reason for the Pexon transfer. It would also support a finding he wasn't being truthful. However, the learned judge had already impeached his explanation as inherently incredible. As such, it wouldn't have any additional incremental effect on his assessment. As we said in paragraph 160, that's not the point. The point of it is it going to make a difference to the Court of Appeal's assessment of this point? The judge's findings were under attack in the Court of Appeal. And if the new explanation confirmed the suggestion put to Mr. that his financial difficulties were the real reason, that would obviously give the Court of Appeal important assistance when they had decided whether to uphold Bannister J. And we found an example of that in the case of the Olympic and HMS Hawke in 1913, where the question was whether in the Court of Appeal the discovery of wreckage below the scene of the collision after the trial before the Admiralty Judge and before it reached the Court of Appeal, but which supported one of the parties' case, should be admitted. And Lord Justice Vaughan Williams, at the page we've mentioned, paragraph 161, makes it quite clear that the Court of Appeal had admitted it because it would be helpful to them. So since she had herself acknowledged that the new explanation confirmed the suggestion which I'd put to that his financial difficulties were the reason, it should have been admitted and it should have been relied on, and your lordships should admit it and take it into account when deciding.
The real reason why the Court of Appeal refused to admit it is surely that they actually thought that it would confirm their view, because they said in paragraph 46 and again in paragraph 108 that it would not provide a further and essential underpinning for the judge's conclusion that there was a sale. It would only make sense on the basis that in order to deceive creditors, Mr. Nung intended to retain the beneficial interest in the shares.
Yes.
And you take head issue with that. You say, not so. If you're being afflicted by your creditors, the honest way to avoid the risk, or if you fear some future attack by creditors, the honest way to avoid the risk would be to transfer the money into your partner's name. And then you may find the transfer is set aside, but it's a genuine transfer.
That's right. And that's part of my long diatribe against the Court of Appeal on, it's beginning with paragraph 77. Madam Justice Kentish Egan's explanation shows she'd misread tribe and tribe as well. And we say at para 90 that she overlooked what Lord Justice Millett said at the end of his judgment in Tribe and Tribe summarising the law. Top of page 23 of our case, 87 in the bundle, the only way in which a man can protect his property from his creditors is by divesting himself of all beneficial interest in it. Evidence he transferred the property to protect him from his creditors does nothing by itself to rebut the presumption of advancement. It reinforces it if he transfers it to his wife or his son, so that the presumption of advancement arises. To rebut the presumption of advancement, it's necessary to show an intention to retain a beneficial interest and conceal it from his creditors, which was the facts in Tribe and Tribe, except for the locus penitentiae point. So,
I don't understand the next paragraph.
Sorry.
The next paragraph in Lord Justice Millett, the court shouldn't conclude this was his intention. In other words, shouldn't conclude that he intended to retain a beneficial interest without compelling circumstantial evidence. The identity of the transferee and circumstances of the transfer would be highly relevant. And then it's unlikely that the court would reach such a conclusion where the transfer was made in the absence of an imminent and perceived risk threat from known creditors. So it's unlikely the court would conclude there was an intention to retain a beneficial interest if there was not an imminent and perceived
one
threat.
would think that
That's the opposite way around.
Perceived threat would make it all the more anxious to.
Exactly. It seems to be the wrong way around.
Yes. Well.
Maybe unlikely should read likely. But
Yes. Well.
have we checked it against the original text? I'm sure you have.
So anyway, we say that bit of evidence, and it's quite complicated. The story is set out in the case, our case at pages 100 to 101 of the bundle, paragraphs 147 following of the case. And Mr. had 6 weeks to respond to this, and he did file an affidavit about it. But what he said was that his advocate in Macau who pleaded this had clearly invented a reason or misunderstood my account of my reason for wishing to hide my beneficial ownership of the shares. And then 152 of our case set out 5 reasons why that is obvious nonsense. May I just correct a typo in that, or 2 typos in this part of the case. In subparagraph 1525, line 2, possession, it was a mistake for removal. So she'd signed an application for permission to amend the Macau removal defence.
Thank you.
I'm
Page 102.
Yeah, 1525, yeah.
And
Removal, second line.
also
Yeah.
on 101 at para 150, last 2 lines, the last bracket after the word earlier should actually be after the word defence at the beginning of that line.
Right.
Advocate Susanna de Souza So, who was the Chinese or Cantonese-speaking advocate who had taken his instructions for the Macau removal defence only 10 months earlier, etc. But if your lordships are interested in that point, your lordships will be able to follow the details.
Well.
Now, the other point, which is an application we made
Yeah, you better take this quickly because you're running up in time difficulties, allowing for the other submissions you may have to make. Yep, of course.
it's a separate bundle,
Yep.
and it's a separate electronic bundle. It doesn't appear to have been printed as a hard copy.
Okay.
What we relied on was a judgment delivered in Macau in 2015,
Yes.
which we'd already made much of in the application for conservatory relief, so that Lord Newborough and Lord Mance and Lord Hughes
Yes.
treated to that in November 2015. There was nothing new about it, but we seek to rely on it for this purpose. And what the Macau court decided was, the Macau court heard oral evidence on the Katai Strip project,
Yeah.
and the Macau court consulted or asked for information officially from the government of Macau about it.
So where do we find this?
And they rejected it.
So where do we find this?
I'm not sure we have this
electronic.
I'm not sure we have the electronic bundle. I've got at any rate 4 electronic bundles, of which 2 are complete bundles, one of which runs to, they're all lodged on, how many kilobytes is it?
It's the,
How many
how many what?
kilobytes? I'm just trying to identify which one it is by kilobytes, simply. Sorry, I don't know how else to do it.
Does it have a page number?
Well, Lord, there are 3 electronic bundles.
Yes, which one is it?
Starts at the beginning. One's called the record, one's called the application bundle, and one is called the appeal documents, I think.
Which bundle is it in?
It's the smallest bundle.
Right, well, I've got one. That's the statement of facts and issues, which is a separate
It's a
bundle.
completely separate case lines bundle.
Right.
Case lines.
I've got yes, I see. Well, the smallest bundle I've got apart from that.
I'm not sure we've got.
I don't think we got called, no.
We've got it on our own bundles.
Yeah, I'm sorry, we haven't got it.
I'm afraid I only discovered at the short adjournment that,
Well, perhaps we better deal with it tomorrow when we've all got it, rather
yes,
than worrying about
may
it.
we leave it
Let's leave it.
tomorrow, and I'll make sure that
Yep.
hard copies of that. It's quite a
Excellent.
small bundle. I'll make sure hard copies
There,
are
there is something with the first affirmation of Francisco Letao. Is that there is a small bundle with 3 documents, the third of which is an affirmation by a lawyer
Francisco
employed in Macau.
That's
Is
the
that the
one.
bundle you're looking
That
for?
is the one.
Well, it's application bundle part 1, the first document in our.
In that case, we have it not in electronic form, but we do have it in hard form. Yep, thank you very much. Lord Hodge has come to the rescue. So what do you want us to look in at that?
Well, I'm going to have to do this from memory.
Or should we deal with it, let's deal with it later rather than on memory then.
Yes, it's what we need. All we need to look at is what Advocate Letao says about the Macau judgment. He exhibits a Macau judgment in Portuguese with an English translation, and he explains it in his affirmation. And the Macau judgment is in 2 parts. The way it works in Macau is the court decides at an early stage, or well, before the ultimate trial date. It draws up a list of factual questions, running to sometimes to well over 100. And then, after the trial, it first of all answers each of those questions by simply saying proven or not proven. And then on that basis, the court delivers a judgment, a narrative, and reasoned judgment of the sort we're used to.
Well, we may need some help because, as I see it, we've got the affirmation of Mr. Letao. It refers to an exhibit, which we don't seem to have in the bundle.
Lord, I'll make sure that
So,
there's a proper hard copy bundle tomorrow, and if
excellent,
I may
okay.
have 10 minutes to deal with this
We're going to
tomorrow.
have 10 minutes to deal with it tomorrow. Yes, of course. Thank you very much.
I think, Lord, I can give way to my learned friend at this point.
Right, thank you very much indeed. Thank you, Mr. MacDonald. Mr. Deverne,
So, thank you, my lords. I do not wish to follow.
very much. Mr. Parker.
My lords, as you appreciate, we say it's all very simple.
Yes?
The court has found that the beneficial interest in the shares was held by Mr. Ung. For Madam Chen to say that nonetheless she has the beneficial interest, she has to say how the beneficial interest has moved from Mr. Ung to her. She didn't say how the beneficial interest had moved from him to her. In fact, she specifically said in her pleadings that it had not moved to her. She specifically said in her evidence that he would never have transferred the beneficial interest to her had he had it. And we say that's the end.
Have it. But she didn't have it. That was her evidence, wasn't it?
Her evidence was that she had it, yes. But there was no alternative case. We've emphasised in our written case how difficult it would have
Alternative
been.
case, presumably that she didn't have it.
The alternative case would have been, and if I didn't have it, it was transferred to me. She never ran that alternative case. It would have been very difficult for her to have run that alternative case. It made life easier in the presentation of her only case not to have that alternative case. Mr. MacDonald now says that Mr. Justice Bannister had it right, and that, in fact, Mr. Ung had sold the shares to her. He's pinned his colours to the mast. When he opened this morning, he said, Mr. Justice Bannister had it right. It was a sale. But it is absolutely obvious, the one thing that's not pleaded is a sale. Now, Mr. MacDonald says, well, if you look at the pleadings, we've pleaded an estoppel, and we can obviously have to look at the pleadings again in a moment. But I think we can all accept, if you're intending to plead a sale, you don't do it by pleading an estoppel. They're different things. You don't plead a sale for a consideration of $40,000 US by means of an estoppel. You call it a sale. In this defence, a sale is never mentioned. Consideration of $40,000 is never mentioned. And then when my learned friend relies upon the judgment of Mr. Justice Bannister is dealing with a sale. He says it's a sale. He doesn't say it's an estoppel of any sort, he just says it's a sale. But unfortunately, for my learned friend, Madam Chen's case was never that it was a sale, and therefore it wasn't open to the learned judge to make the ruling that he did. Now, another way of testing what's obvious from the actual document of the defence itself is to consider how Mr. MacDonald proceeded at trial. Mr. MacDonald cross-examined, all too briefly, to the point where we say he didn't put any sort of case, Mr. Ung. Now, Mr. Ung put forward his explanation as to his motivation for the transfer. If Madam Chen's had any sort of case about this being a sale, Mr. MacDonald would have put to Mr. Ung that he was talking nonsense and that the transfer had been a sale. It's as simple as that. Of course, he doesn't, because Madam Chen hasn't got a case that it's a sale. So the notion of a sale is not pleaded, the notion of a sale is not put, and of course, we make the point, and the Court of Appeal especially refer to it, it's a slightly absurd notion to be saying that there was a sale to me by somebody who was my trustee. So she says that Mr. Ung was her trustee. Well, her trustee isn't going to be selling her the shares. So it was, as I say, it would be very difficult for her to plead the case, but she didn't. So Madam Chen is saying that the transfer document did not do what, on its face, it appeared to do. It did not transfer the beneficial interest. And Mr. Ung was also saying that the transfer document did not do what it appeared to do. Both parties were therefore agreed that the transfer did not do what it appeared to do.
Wasn't it Mr. Nung's case, at least in the alternative, that there may have been a transfer but subject to a covenant for retransfer 6 months down the line? And doesn't that amount to saying the documents mean what they appear to mean on their face, but there's a qualification, there's a side agreement?
He pleaded it in paragraph 36 on the basis that that arrangement gave rise to a position where she was nominee.
Paragraph 36 of...
I mean, you start with paragraph 14, don't you? Paragraph 14 starts...
Which page are we on?
This is page 246 in bundle 03.
Paragraph 36 of the amended statement of claim, page 300. It's bundle 3, tab 11. Lord Hodge observed about its positioning. It's in a strange position, paragraph 36, because it's in the section on the transfer being void, which appears to relate to the case that wasn't pursued about the alleged significance of the bank charge.
Well, don't we have to start with paragraph 14?
Well, my Lord, your Lordship's quite right, because this is referring back to the story that, in paragraphs, the explanation in paragraphs 14 through to 16.
296.
Yeah, here we are. This is the tale. I give her the shares, and there's a covenant. She'll retransfer after 6 months.
Yes. And
'16.
Lord Mance is right that it's not the explanation doesn't address what the legal consequence of is had that arrangement be implemented. That is made clear. The legal consequence is made clear in paragraph 36.
But wait a minute. Forget the legal consequences. That's a matter of argument. Doesn't even. The essential point is, he was saying, yes, I transferred the shares to her, yes, it was a genuine document, but there was a separate agreement or a connected agreement or a contemporaneous agreement or arrangement that in 6 months' time she'd transfer them back. Now, is the judge entitled to say, well, I accept half of that, but not the other half?
Well, as a theoretical question...
Well, it's not theoretical, because that's what the judge did.
He's not entitled to do it. He's not entitled to do it here because everybody was agreed that the transfer document did not transfer the beneficial interest, and no one suggested that it did. So it wasn't open to the judge to proceed on the basis that it had done.
Well, you don't wonder about transfer the beneficial interest as a separate item of property. What the documents did was to transfer the shares. Now, if that's the whole of the story, the answer is the entire interest is transferred. But what was said is it isn't the whole of the story, because there was also an understanding that Mr. Ng would have certain rights, including a right to have them retransferred to him. Now, one can argue about whether that gives rise to an equitable right or to a purely contractual right, but on the face of it, the documents were a complete transfer unless qualified by some other agreement. Your pleading was that it was qualified by some other agreement, but the judge didn't believe it.
Well, my Lord, that is a way in which the defendant could have approached the facts of this case. They could have said, with Mr. Ng's story, save that, there was never an agreement to return it after 6 months. They could have said, yes, this transfer was for the reasons put forward, and it's just like, it's like a tribe and tribe situation, except the deception, except it's not a deception. Now, the point about paragraph 36 is saying that this transaction and the explanation, as a consequence of the explanation Mr. Ng puts forward, is a deception of the authorities. because Madam Chen is to present herself as a woman of wealth based on all the documents. But Mr. Ng is saying, well, that's a deception, because she's not a woman of wealth, she's simply my nominee. And that's the same situation in the creditor's position. You can either deceive the creditors by concealing your assets through the use of a nominee, or you can simply give your assets away and say to the creditors, I don't have the assets anymore. But the transfer can achieve either of those objects depending on what the intention is. And Mr. Ng in paragraph 36 is saying, my intention behind the transfer was to make her my nominee.
What's the first sentence mean, if that's right?
First sentence is,
36.
sorry.
36, that it's clearly, as a legal analysis, his intention was to give her nothing. Now, as we talked about this morning, the legal title goes over, but it's just like a sham trust. When the authorities talk about sham trust, they use the expression sham, but the settlor does transfer the legal title in the property to the trustee.
But you accept that if he was intending to make her a nominee, what he said in the first sentence is nonsense, because he had to give her legal ownership.
Yes.
Indeed, it makes a nonsense. It doesn't fit in with the second sentence.
But the point about not never intending to transfer the beneficial interest does fit with the second sentence.
Yes, I mean, that's his primary case, but he's got an alternative case, hasn't he, or at least a potential alternative, which is, all right, there's an agreement to transfer back. That's paragraph 16. Why isn't it open to a judge to say, I'm sorry, I think that the documents on there bear their face value. As to your argument that there was an agreement to transfer back, I don't believe that.
Well, because that wasn't his case, and it wasn't Madam Chen's case.
It
The
was
halfway house...
But it was his case.
No, the halfway house is not something that anybody's contending for, because he is specifically saying, I never intended to transfer anything to her.
But he can't be right about that if she was to be his bare nominee holding the shares on trust.
Can't be right as far as the legal interest is concerned,
No.
yes. But he can be perfectly right as far as the beneficial interest is concerned.
Yes.
And Madam Chen's response was at no point to say, well, I agree with the notion, I agree with the explanation for the transfer, but there was nothing about a 6-month return, and it was intended that I got the beneficial interest. Had she said that, had she said, well, I agree with him, and I was intended to get the beneficial interest, then the approach of the judge would be unobjectionable. This is not about...
What's the judge supposed to do
right.
If both parties are saying, OK, there was a transfer, but it was on terms X in the submission of one side and on terms Y in the decision of in the position of others. So the judge concludes, OK, I accept that there was a transfer, but I reject both X and Y. What is he supposed to do? Simply give up the whole case as a bad job? I mean, he's left, having rejected all the ancillary aspects of this agreement, with the one point that is common ground, which is that there was a transfer of the legal interest with no reservation of any other contractual or equitable right. So what's he to do?
Well, he's got to approach it on the basis... at the very least, has got to approach it on the basis of the evidence given. And the evidence given in this case by Madam Chen is that he would never have transferred the beneficial interest to her.
But why can't he say, and I think most people who've been judges have been in this position or close to it, look, I've been told a pack of lies by both parties. I'm only prepared to accept anybody's case insofar as it's backed up by undoubtedly genuine contemporaneous documents. I accept Mr. Ng's case to the extent that he did make a genuine transfer because I've got the documents, and I'm afraid that's where it stops, because there's nothing else to support what anyone else said, and I don't believe them.
Well, he's not accepting Mr. Ung's case,
No, he's
because
not.
Mr. Ung's case is quite clear that
He's accepting
the
part of
transfer
it.
was only of the legal title.
Yeah, but he's
going-
he's accepting Mr. Ng's case that he signed the document and it had some effect of transferring. And all he's saying is, I'm going to accept the case, I'm going to accept this document as genuine. The document's a piece of evidence. Everybody agrees that it was signed. And what he's saying is, this is the piece of evidence that I'm going to fasten on, because everything else I've heard, don't believe a word of it.
Well, because it's not the judge's job to pronounce on what he thinks happened. It's the judge's job to decide between the two positions put forward.
So he's got to
And
accept the whole of each party's case or none of it. Is that the position?
Well,
About 29–30% of the cases wouldn't come to an end on that.
he can accept part of one party's case to the extent that the other party is in agreement with that case.
What?
If Madam Chen had said there was a dispositive transfer and that's how the beneficial interest arose with me, then it would have been open to the judge to find there was a dispositive transfer.
Why can't he accept what your client said, whatever Madam Chen said?
Because my client didn't say there was a dispositive transfer.
Why can't he accept part of what your client said? You appear to be submitting that unless it's common ground, he can't accept part of what your client said without accepting the rest. And this is an interesting doctrine which I don't believe has yet been applied by the courts.
Because my client this wasn't, the point that Lord Sumption's raising isn't a question of what my client is actually saying. He's simply pointing to a document and giving an effect to that document for which neither side was contending.
Well, let us take a case of a will. Two parties contesting a will. The claimant says the will's a forgery. And the defendant says the will's genuine, but actually the testator meant something different from what he appears to say. Surely it's open to the judge to say, I think the will's genuine, and I'm going to give it effect as to what it means, because I think I'm not satisfied the testator meant anything else. Now, he's not giving effect to either party's case, but that must be open to the judge in a case like that, mustn't it?
Well, that's very different because it's a point of detail. That's why one side is saying the will is a dispositive document and the other side is saying it's not a dispositive document.
Well,
The court is finding it's a dispositive document and then one moves on to the question of construction. I can't accept the construction that's being put forward.
one party says the will's forged, and the other party says one of the witnesses to the will wasn't there when the other witness signed it. So they're both impugning the will. Surely the judge can say, I don't believe either of you, I'm going to uphold the will.
Wills may be different, and there may be a public policy aspect with respect to distributions of a deceased person's estate.
Maybe.
But where one's talking about a question of agreement, a contract between two people, and the whole basis being consensus ad idem, the one consensus ad idem that's manifested by the pleadings is that the beneficial interest was not transferred. And fundamentally, given the finding...
Maybe it was transferred as a matter of construction of the document.
But that's where the notion of sham, facade, pretense, what have you, would come in, because you could have a document
It'd just
which
be a
on
question
its...
of construction.
If you construe the transfer, it transfers the beneficial interest. But the parties are agreed that it did not transfer the beneficial interest. No one deploys the transfer in these proceedings as a disposition of the beneficial interest. Not having done that, it wouldn't be open to them on appeal to say, well, the judge found that the beneficial interest therefore remained with Mr. Ung. It wouldn't be open to them on appeal to then say he should have found that the transfer did transfer the beneficial interest, because if you look at it and construe it ordinarily, it transferred the beneficial interest. It would be said against them, but you never pleaded that.
Can we go back then to what the judge should do, or back to Lord Sumption's question? The judge disbelieves both parties. They're both telling a pack of lies. Maybe a bit harsh in this case, but anyway, he disbelieves both parties. What's he to do?
He decides it in accordance with the position as found as a consequence of the rulings on the party's case. There's no difficulty here.
Doesn't he just say the shares are with Mrs. She's recorded as the owner. I don't believe anybody's case, therefore the position is as it stands. She's the owner of the shares.
But he has decided that the beneficial interest before the transfer was with Mr. Ong. And nobody has contended, nobody has come to court to say to the court the beneficial interest is moved. So it's not open to the court to say, as if it was some investigatory body, but I think nonetheless, despite the parties to the alleged contractual arrangement being absolutely clear on the topic that it didn't move, the judge then finds, I think it did.
But surely he doesn't go back to the past. He says, look, the shares are owned by Mrs. Chen, they're vested in her. I don't believe anybody's story is how they've got there. I can't therefore change the status quo.
The status quo is the beneficial interest was with him, and she was not.
That depends on the judge believing his narrative, and he didn't.
Prima facie, if I own shares, they're my shares beneficially. Somebody's got to prove they're not. If he doesn't believe anybody's story, the status quo surely is that they're her shares.
The status quo on what the parties were contending the position was that the beneficial interest stayed with Mr. Ong. She told the court that if she was wrong on the issue of the beneficial ownership before the transfer, the beneficial interest stayed where it was.
That's building an awful lot onto one sentence in her evidence, which may be no more than a throwaway.
Your submission appears at first sight to be based on the heresy identified by Lord Brown Wilkinson in West Deutsche Landesbank when I made the same submission to him standing where you are. That you do not ask yourself in relation to a transaction whether the transfer includes the beneficial interest. A transfer is a transfer of the total interest unless there is something which will cause equity to impose a trust upon it,
Yes.
e.g. an agreement or in some cases a constructive trust, but we're not in that area. Now, on that footing, the transfer was prima facie a total transfer unless a narrative was accepted by the judge, which indicated that there was an imposition of a trust, and the narrative was not accepted by the judge. So what you're left with is a complete transfer. You can't speak of it doesn't matter that the parties did not expressly say, and I pass the beneficial interest to you in addition to the legal interest, because that goes without saying, unless there is a trust, separately agreed.
But it's a question of procedural unfairness. If both parties are saying it didn't pass the beneficial interest, then there's no notice to Mr. Ong that he needs to be exploring in detail the circumstances in which the transfer came to be drafted and mentioning the consideration. I mean, the mention of the consideration of $40,000 is baffling, but it doesn't call for any investigation by Mr. Ong, because he knows that Madam Chen has specifically pleaded that the beneficial interest was not transferred. So he doesn't need to worry about that. All he needs to worry about is demonstrating to the court that he had the beneficial interest before the 4th of October. And that is why it's not open to the court simply to say, well, I don't believe either of you. There's another set of circumstances, contrary to what Madam Chen has said, whereby the beneficial interest was transferred.
But
and even though you... Sorry.
So he pleaded his case, as we see in Bundle 3, tab 11, and presumably he gave evidence before Madam Chen gave her evidence. Would that be right?
Yes.
Yes. So he didn't know he was going to get this windfall on which you're founding, namely her statement that he would never have given me the beneficial interest. So
that's correct. But
so where is this idea that he was misled by her case.
Well, it's paragraph 17, which we didn't look at this morning, of the defence.
Page?
Tab 14,
Yep.
and if we go to, it's 17, E and K, I believe, in particular.
Paragraph, which, 17 E and,
Page 350.
yes, E and K, yep.
The 17E
Yes, I see.
specifically states the beneficial ownership of the shares was never transferred, and then over the page on 351 at K, he's in the middle of K, the instrument of transfer was and remains legitimate, valid and effective as a transfer of the legal title of the shares from Mr. Eng to Chen. So Mr. Eng at all times knew that it was not going to be suggested to him transfer was a dispositive document.
Yes, I see.
Which is why when we go back to consider the pleading of the estoppel, we saw this morning, my lords, that it is said, the estoppel that my learned friend concentrates on is at 344. Transfer, it is said, is to implement the 1996 All Agreement, which is why there's no new consideration. It's simply performing the allegedly previous existing obligation. And then we see at P, at all meal times, Chen relied on the contents and effect of the documents. Now, the transfer is not identified as having any particular significance compared to the other documents. So the one document amongst the documents which could have a dispositive effect isn't relied on as having a dispositive effect. It's simply relied on as part of an estoppel. And the contents and effect, well, we're not told, there's no pleading of what the contents and effect of any document other than the transfer is, and the transfer is specifically pleaded as not being a dispositive document. So when at Q, it says the documents existed and were effective, Madam Chen has said the transfer was effective only to transfer the legal title. It specifically said the beneficial interest didn't pass with it.
Because it already had passed. So it was effective to complete the transfer of the combination of legal title and beneficial title.
But why do you restrict this as a plea to, by reference to the other part of the pleading? Isn't this consistent with looking at the documents on their face and no further, and simply saying this is what the parties agreed and they have that effect, whatever it is in law?
Well, as an estoppel, it's based on reliance, and there's no evidence of reliance. The estoppel argument was not actually presented at trial. If we look at her witness statement,
Where do we find that?
When you say the estoppel argument, do you mean the contractual bar that was raised at the beginning of this morning's proceedings, or are you talking about estoppel by convention?
yes, sorry, the contractual estoppel is nowhere pleaded.
Right. Well, I think that's accepted.
Yes.
But you're not disputing that the estoppel by convention was pleaded, are you?
Well, it's a question of what the estoppel was. The estoppel, as pleaded, looks to be a representation through the documents that she is the beneficial owner. And she goes on to say, and she relied on that. That's what she says in the pleadings. But we don't find that in her witness statement or her evidence. On page 544,
Bundle?
it's in bundle 4, tab 9.
Yep. Yes?
She simply recites 223.
Sorry, is this per page?
It's at page 544,
Yep.
paragraph 223 onwards. She recites the documents
I'm not with you yet.
But you will not find anywhere in the evidence any claim that she ever relied on content.
In order to have a estoppel by convention along the lines that we were hearing about this morning, do you need reliance? The prime site and the Lavarello lines?
No, but
By deed.
prime site.
Yes.
I think the position is you do need it for estoppel by convention, properly so called,
Yes.
but you do not need it for what is effectively a contractual agreement as to the basis on which the parties are to proceed.
And I would accept that. Now, just comments on prime site. One appreciates prime site wasn't concerned with whether a contractual estoppel that hadn't been pleaded at the trial could be relied upon on appeal, because prime site arose in the context of opposition to a winding up petition. Simply a question of whether or not there was an arguable case. Therefore, obviously, contractual estoppel, so we could run a contractual estoppel at the trial, and therefore there's a bona fide dispute. In prime site, there's no dispute about the proprietary effect of the assignment.
No.
The property was transferred. The question was, given that the property has been transferred, was the consideration outstanding? But of course, here, it's a completely different question. The question is whether or not the property was actually transferred. The question of whether or not the consideration is outstanding obviously simply doesn't arise because everyone is agreed the property was not transferred. So the contractual estoppel in prime site is utterly beside the point. Now, this isn't, when I say the pleadings are clearly on the basis that the transfer is not a dispositive document, this isn't our coming at it after the event and saying, well, despite what everyone's understanding might have been during the course of the trial, we're looking at the pleadings and saying, Mr. Hockhauser's rather assumed things that weren't there. Mr. Hockhauser at the trial specifically made the point that they were not relying upon the transfer as a dispositive document. And we find that page 1600 to 1601, tab 9, bundle 9.
Bundle 9.
I'll read from line 19 on page 1600. Just take it in my submission, the foundation of their case is the transfer was not a new transaction. It was the performance of a pre-existing obligation. So they are establishing their entitlement to the equity based upon the fact that she was the beneficial owner. If your Lordship finds in 1996 that she was not and she has misled the court, then those documents simpliciter would not transfer to her the beneficial interest in my submission. That is not how they put their case. So he understood their pleaded case to be in accordance with its terms. Beneficial interest wasn't transferred by the transfer. No reliance on the transfer as a dispositive document.
And he goes on to say there was no challenge to Mr. Ng's statement in his witness statement, where he said we reached this agreement that she would hold the shares temporarily for 6 months, which is his paragraph 16 assertion.
But he's saying that's on the basis that my intention was to deceive. And we say that if she had said, alternatively, the transfer did transfer the beneficial interest, we've set out in our written case all the difficulties that would give rise to. We said it would be fundamentally unfair for her to do that at the conclusion of the trial, to see how she goes on her only case. Then if she thinks she's lost that one, to plead by way of amendment an alternative case. But if she had been able to do that, then obviously the response would have been, no, the transfer was a sham, pretense, a facade. You yourself pleaded that. You, Madam Chen, said it's a sham. It didn't transfer the beneficial interest.
But that assumes that it purported to do so.
We accept the transfer on its face purported to
It
transfer the
didn't
beneficial
purport
interest.
to say anything about the beneficial interest. It simply transferred the shares.
Well, so far as, my Lord, you're referring to the fact that prima facie it would carry the beneficial interest. The fact of the consideration reinforces that. We accept that. If the transfer for a monetary consideration, you would ordinarily, as a matter of construction, to take Lord Clark's point, you would say the beneficial interest was transferred. But in circumstances where the parties are saying to the court, no, that's wrong, it didn't transfer the beneficial interest. No one is coming to court to say this transfer transferred the beneficial interest. And in those circumstances, the judge is not adhering to the adversarial system and deciding the question as put to him.
It's slightly odd to talk about the beneficial interest. I think this is the point Lord Sumption's putting to you. If I own shares or house, etc., and it's just mine, in a sense there isn't a beneficial interest, it's simply my house or my shares. You only meaningfully talk about a beneficial interest when the legal interest is encumbered with some other rights. It's treated as an interest in English law, but if I sell you some shares, I sell you the shares.
Well, that was effectively what Westdeutsche Landesbank decided, rejecting the heresy of Peter Birks, who had argued the opposite in his books.
But in all these cases, one party is contending that the document did what it would have appeared to have done, namely to transfer the beneficial interest. And what is unusual about this case is the party who would ordinarily have said the document did what it purported to do and transfer the beneficial interest is categorically saying that it didn't do that because she wants to run the false case that she had the beneficial interest before the transfer.
If we were to decide that actually on Mr. Ng's case, if it had been accepted, the beneficial interest would have gone to Madam Chen, but he would have had no more than a contractual right to have the shares back in 6 months. That wouldn't alter your case, would it? Wouldn't alter what you were standing on.
She would still...
No, it wouldn't alter what you were saying today. I mean, I wonder if the beneficial interest is simply a chimera that we don't have to worry about. As I say, let me repeat the question. If it was to be the case, as a matter of law, that if Mr. Ng's case had been accepted in its entirety, the right legal analysis was that she got the legal and the beneficial interest, but she had a contractual obligation to transfer it back to him in 6 months, so that she did get the beneficial interest.
Well,
If that was the case, would that undermine your whole argument before us? Or would your argument be equally strong? It would be a bit surprising if it undermined your argument.
well,
And yet, it seems to me you're making a lot of the beneficial interest, and I wonder if it really matters what the correct analysis is.
well I fear I'm a little behind, Your Lordship. If it's on the basis that one simply says, well, the beneficial interest goes over, but it goes over subject to a specifically enforceable contract for it to come back, then I would submit that that does actually still give rise to a trust relationship.
It may give a trust relationship of that very odd type of trust, yes. But nonetheless, the beneficial interest goes because it has to go, so you have to have the beneficial interest back, as it were.
Yes.
But all I'm saying is whatever the correct analysis of the position, surely it doesn't affect your argument. Your argument is simply that the judge found in favour of analysis which neither side ran. Or is it essential?
No, it's not essential. No.
That's why I wonder whether we should need to spend too much time worrying about the correct legal analysis. Basically, you're saying he found us combination of facts that he wasn't entitled to find, because it was neither side's case.
But it might be closer to Madam Chen's case in the sense that the judge, there was clearly cross-examination of her, and she clearly put up an answer to the suggestion that there was any agreement to resell.
Quite.
And so the judge might accept her on that point, but that would simply leave a transfer of the beneficial interest, but without any explanation or qualification.
In my submission, this illustrates the fundamental unfairness of this exercise, because the point at which we're talking about, well, a bit of this, a bit of that, in circumstances where the parties have not had the chance to comment in terms of questioning or any preparation for the case. Learner Friends put a one-liner in cross-examination about the transfer perhaps being because of financial difficulties, without any exploration as to whether he was talking about a transfer of the legal title, which is what his client insisted the transfer only was, because as we've talked about, one can transfer the legal title because of financial difficulties, intending to retain the beneficial interest. So that was never made clear. But we don't find in the defence any of the necessary averment, given that this was a positive case that was being raised. There's none of the necessary averments that the transfer was related to financial difficulties in circumstances where the intention was to transfer ownership in the true undivided sense because of financial difficulties. It's just not there.
If we go back to the point you say, the judge having rejected the oral evidence of both parties as unreliable, you say he should have therefore gone back to the position that Mr. Ng was the owner. But where does that leave the transfer document?
The transfer document does what the parties were agreed it did.
Well, they were not agreed with what he did. I suppose you say it leaves it in the sense that they agreed that it transferred the legal ownership, but not the beneficial ownership.
Yes, because they agreed it was not a dispositive document. It was.
You say it's not. That itself is a question of construction of the documents.
It's not, my lord. It's got to be deployed. The parties have got to deploy their weapons. If she says that the transfer is a weapon, she deploys it. She says it's not. She says it's irrelevant, other than as just another document on which she pleaded an estoppel, which she never ran at court. She never came to the court and said, the beneficial interest was transferred to me. And the court can't therefore decide something that was never actually being put before it. If she had said it did transfer the beneficial interest to me, then Mr. Ng would have been on notice and Mr. Ng could have decided how to respond to that. Maybe he would not have had an effective response. But that's not for this court to decide at this juncture.
Well, it's difficult to run alternative factual scenarios, especially when they're inconsistent. Parties may, for a variety of tactical reasons, confine themselves to their primary case, in which case the judge may have to rely on the one piece of evidence that's incontrovertible, namely that of the documents.
Well, the Ahmadeni case says that there can be all sorts of reasons why people don't run a particular case, but they have to live with the consequences of that. And it may be that, that evidentially we only see clearly one statement about her thinking that led her to insist that the transfer wasn't dispositive, to put forward a case that she always had the beneficial interest, which was that her thinking was, if he had the beneficial interest, he would never have transferred it to her. Now, she only said that the once in cross-examination, but that would provide an explanation as to why she was proceeding on the basis that the transfer wasn't a dispositive document. Because her thinking was, well, look, nobody would give away the hotel. Never mind my learned friend talking about 20 years of love and affection. The love and affection did not play on her mind to the point where she was saying, well, of course he gave me the hotel. I was effectively his common-law wife. Not her case at all. Her case was he would never have given it away. And that is consistent with the way she pleaded the case. So it's not getting a windfall after Mr. Ong is giving his evidence.
On the face of it, if you just simply read the instrument of transfer, on the face of it, at least, on the face of the document, it's a transfer of the 40,000 shares, which will transfer the legal and beneficial interest in the shares.
Correct. Correct, on the face of it.
So you need some variation of it or some other agreement to vary it.
Or
You haven't got that.
Or you say it's a sham. Or you say it was intended to take effect differently from the obligations appearing therein, which is what both sides were saying. So there's no need for Mr. Ong in reply to say, but the transfer only transferred the legal title. It did not transfer the beneficial interest. No need for him to say that, because that Madam Chen has already said that. They're agreed on that. They're agreed this is a sham within the wording of the SNOOC. Obligations different to what appear on the face of the document.
Well, now, in his case, the obligation wasn't any different. It merely left out another important obligation. Didn't it?
The obligation to retransfer.
The obligation to retransfer. It wasn't a sham. Just didn't
On
tell
that reading, my lord, on the reading that
didn't tell the whole story.
Well, that's his paragraph 16. That's where he's giving the factual statement. We then get on to paragraph 36, where there is an incoherent statement between sentences 1 and 2. And if his position was, it was a sale, but I didn't demand the consideration because she was going to have to give it back by virtue of a second agreement 6 months later, then his position was that there was a transfer, absolutely, of the shares, subject to the other contract.
Which, as a matter of law, may well, or equity, may well have resulted in the beneficial interest bouncing around, but that's a different point.
But in my submission, we're confusing two things here. If one looks at the facts that are being pleaded, then the fact that was pleaded was that there was an arrangement to assist with the Kotai Strip project to transfer the shares to her. That's not what the court found. That's not what Mr. Justice Bannister found. Now, if you're looking at the question of the legal consequences of the transfer, then the parties are agreed as to what the legal consequence was. Now, if the judge in this case had said, well, I'm accepting what Mr. Ong says, I do think this transfer related to the Kotai Strip project, but I find against the notion of a six-month return, then at least that decision would have been wedded to the presentation of one of the parties. If that's what had happened. But it's not what happened, and it's not what the learned friend is contending for. The learned friend is contending for a legal consequence of a document, which is the legal consequence that both parties disowned, disavowed. And it's not, therefore, in my submission for the court to say, despite the fact nobody says that was the legal consequence of the transfer, I'm going to find it was the legal consequence of the transfer. And it's fundamentally unfair.
If it's the effect of if it's on the face of it, the effect of the transfer, what's wrong with that? Anyone reading the transfer would say, well, he's transferred the shares away.
And it's not an in rem declaration against all the world where everybody's got an interest. This is a document between two parties who are both telling the court this document did not transfer the beneficial interest. This is not a dispositive document. And it's quite extraordinary in those circumstances for the court to say, oh, but it is a dispositive document. I insist it's a dispositive document.
I mean, there's not just this document, there are a whole series of documents, aren't there?
But the other documents are not dispositive.
They're all contingent on the disposition, really.
The other documents can only have a legal effect.
And maybe so, but you don't get, well, put it this way, you don't get any hint for any of these documents that the transfer document doesn't do what it says on the can.
No. And Mr. Ong's explanation for those documents were that they were to be put in front of other people, that the declaration was to facilitate the actual transfer, and they were for the purpose of deceiving people into thinking that she was the owner. He wasn't cross-examined on that, but now we're sort of getting into the evidential consequences of my learned friend not challenging the evidence. But in terms of the legal analysis, the transfer is not separated from the other documents because they're only utilised for the purpose of an estoppel that was never presented because there's no evidence of reliance. If one separates the transfer, one can see that she's saying there's nothing different about the transfer to the other documents because she does not rely upon it as a dispositive document.
On your case, it's slightly puzzling, is it? The paragraph 5 of the issues to be determined, list of issues to be determined, that's in bundle 04, page 383. Was the alleged transfer a valid transfer of beneficial interests in shares? And then it refers slightly confusingly to paragraph 34 of the amended statement of claim, which alleges voidness. On the face of it, that seems to be the very issue which the judge decided. Have you got it? Sorry.
Yes, I know the document.
Yeah. I agree. You can't read it on its own. You would read it in context, but it's slightly puzzling on your case, isn't it?
It is slightly puzzling. I haven't got an answer as to why it was drafted in the terms that it was. You've seen what we've said in our response. We say, well, the pleadings govern, not the list of issues.
Well, also it's particularly confusing because it refers to paragraph 34 of the amended statement of claim.
Yes.
Yeah, okay.
But we can
That's
see,
a fair answer, thank
we
you.
can see from what Mr. Hockhauser said that
No.
he wasn't approaching it on that basis.
No, and it doesn't seem to have found its way into much of the, if it's read in the way that Mrs. Chen might like it to be read, it doesn't feed in very well to the pleadings and the argument. I see that.
My Lord, I think...
Basically, it comes down, your case comes down to I don't mean this in any way critically. It comes down to an argument saying it's simply unfair to decide the case on the basis of a view of the facts that nobody had adopted and your client never had a chance to answer.
Yes.
Or deal with.
Well, we all know that if something's supposed to be pleaded, then it's supposed to be put. And if you don't plead it and you don't put it, you can't rely on it. And I submit that it follows...
It's not quite so stark as that, the law is.
In my submission, it is. It is, because the transfer as a dispositive document was never pleaded. The transfer as a dispositive document was never put. As I say, a person that doesn't plead it and doesn't put it can't rely on it. And in my submission, if they can't rely on it, it's not open to the judge to say, you don't need to rely on it, I'll do your job for you. You're actually better off because they haven't had an opportunity to respond to any of this. So I'll skip that bit. Something might go wrong. We'll just go straight to giving a decision in your favour on a point you couldn't have relied on because you hadn't pleaded it and you hadn't put it. I've taken rather longer than perhaps I should have done to set all that out in the written case, slightly ad nauseum, but that's why I said at the beginning, we say this is a very simple point. It wasn't pleaded, it wasn't put, and the court can't therefore make a decision as if it had been. My Lords, that's what I have to say on that particular point.
There was some point seen as a separate point about the fact that the judge wasn't entitled to reject Mr. Ng's.
Sorry, on the evidential, yes, sorry, I've forgotten how it's
That's all right.
supposed to go first on that one, my Lord.
Yes, no,
yeah,
don't worry.
my Lord,
It's either more sensible you should go first on that.
yes. Sorry, trying to put it as succinctly as possible. In tab 5,
Yes.
in my learned friend's cross-examination, we can see...
Bundle 5.
Bundle 5. You can see where, in my submission, the error is made.
Yes.
Because the learned judge rejected Mr. Ng's story explanation for two reasons. One is because he said it was irrational. This is a Chong Gold development, and therefore transferring the shares to Madam Chen provides no benefit to Mr. Ong. And secondly, he said because he couldn't believe that he would have done this without requiring a signed blank share transfer form so he could get the shares back. Now, what we've said about that second point is that Mr. Ong was never cross-examined about the fact he hadn't asked for and obtained a signed blank transfer form. And we've said it's easy to understand why he wasn't cross-examined about it, because on Madam Chen's story, she'd done exactly the same thing. He had put the shares in Mr. Ong's name without requiring a signed blank transfer form. And of
So
course,
that's consistent with rejecting both sides' evidence, as the
well,
judge indeed did.
It's a matter of it's an explanation.
I see.
It was never put. It was never put to
Explanation
Mr.
why
Ong.
it was
That's
never
why we
put.
say-
But it's the same point. It was unfair to use it
Yes,
as a reason when it was never put.
fundamentally, yes.
There's no point really looking through the cross-examination.
Oh no. Well, at that point, you
That.
just don't find. You just don't find.
Yes.
And we say, well, of course, it was an irrelevant point, because on Madam Chen's story, her case was she had the beneficial interest. If she had the beneficial interest, the whole point about whether or not he took a signed blank transfer was just irrelevant. That was her case. So you can understand why Mr. Ong's not being cross-examined on it, because the transfer is not pertinent to anything. Which is why you don't find any cross-examination about the transfer. It's not being relied upon as a dispositive document. Now, the first reason we were talking about is the disconnect between the evidence that was given about the Cotai Strip project and the court's ruling. Now, the approach that my learned friend took in cross-examination was to say that by October 2011, the Cotai Strip project was dead because it was effectively a joint venture between Mr. Ong and Mr. Gong, and they'd had a falling out. So it was dead. But Mr. Ong's evidence wasn't in terms of it being a project with Mr. Gong. His evidence was that it was his project. Now, we see that divergence in my learned friend's understanding and presentation of Mr. Ong's evidence and what Mr. Ong's evidence actually was at page 642. It's bundle 5, tab 5,
Yep.
page 642.
Thank you. Yes.
And Mr. MacDonald asks about the transfer. We see at the top of 642, the date of the transfer is identified. And Mr. MacDonald says, and you have said you did that because it would be better for Madam Chen to be holding the shares in order to promote the new casino project between you and Mr. Gong. And Mr. Ong says, no. And Mr. Hockhauser jumps up. He doesn't say it was to promote the project between him and Mr. Gong. He says it is to promote the project, the Cotai Strip project. That's what he says in his evidence. And Mr. MacDonald says, yes. And Mr. Hockhauser, it wasn't to promote the project between himself and Mr. Gong. So, Mr. MacDonald has convinced himself that the only relevant project was one between Mr. Ong and Mr. Gong. But that wasn't Mr. Ong's evidence. And we can see perhaps the origin of the misunderstanding. One goes back to 634, we see Mr. MacDonald's cross-examination beginning in respect of the Cotai Strip. 634, line 8, there came a time when you were proposing to
Yeah,
build...
we looked at that with Mr. MacDonald, yeah.
And he goes on, if your lordships then read to the end of 635,
Yep.
So, what's going on in Mr. MacDonald's mind, as we now know, is he's thinking if he gets an acceptance of the disagreement with Mr. Gong, that means the project must be at an end. As if Mr. Ng's evidence was that the project was only, at all times, a project between him and Mr. Gong. But that's not Mr. Ng's evidence. Mr. Ng's evidence is, at the relevant time, the 4th of October, it was just his project. So the learned judge rejects the explanation on a ground that shows he had not understood the explanation. He's rejecting evidence that wasn't given. Because the cross-examination proceeds on an erroneous understanding of what Mr. Ng's evidence was.
So we go to the judgment. Just can you give us a passage in the judgment? Sorry, just for my note. Sorry.
Yes, it's page 180, paragraph 31.
180, paragraph 31, thank you.
Good.
So the cross-examination is on the basis of this being a project with Mr. Gong. And then it seems to be saying that Mr. Ng could derive no commercial advantage if the project had been successfully obtained by his nominee. And the Court of Appeal say, well, it's not in the least bit inherently improbable that if it was his project, that he would derive an advantage from his nominee obtaining approval for the project.
I'm sorry, I'm being thick, but I don't quite see how Mr. Gong involvement comes into this.
I thought in this passage, what was being said was, by the judge, was that Mr. Ng's fingerprints were all over the deal. Everyone knew about it, and therefore trying to hide behind Mrs. Chen wouldn't get off the ground. That's how I read what the judge was finding there, but I may be wrong.
Well, it's the reference to Chong Gold. I mean, on that basis, the Court of Appeal's observations are very fortiori, because his fingerprints may have been on the project, but if the project's been taken forward, been put forward as a project of Madam Chen, of course Mr. Ng would still benefit.
Isn't the point that's being made here that the story that the shares were temporarily transferred to Madame Chen in order to facilitate the transaction, because it would undermine the transaction if Mr. Ng was seen to be behind it, it is suggested contradicted by the document which he quotes here, which says actually the whole project was dependent on Mr. Ng. So on that footing, it can't have made sense for Mr. Ng to want to pretend to be having nothing to do with it and transfer it to Madame Chen. Now, I don't know whether you can give us a reference to the document that's being quoted here, but that seems to be the point that he's making.
No, I may not have understood. I may have misunderstood that. The one then goes on to the stricture about the fact that the passages that his lordship are quoting, as it appears from paragraph 32,
Yep.
were not put to Mr. Ung at cross-examination or relied upon specifically at trial by Mr. John MacDonald QC. So the only, I'm sorry, I'm not explaining this very well, the only passage in cross-examination that we have is based upon an erroneous understanding of the evidence and it being put that the project was dead in the water because it was a project with Mr. Gong and you'd fallen out with Mr. Gong. And as we've seen, that wasn't Mr. Ung's evidence. So we have no cross-examination. And then the judge rejects the evidence for a different reason, but specifically acknowledges that that wasn't put to Mr. Ung. So it's the same problem in different guise as we've just been talking about, the procedural unfairness of rejecting a story for a reason that wasn't the subject of any cross-examination. And as we've seen, the cross-examination proceeded on a misunderstanding. I'm sorry, I've conflated all that in my written submissions. I do apologise. Hopefully I'm being clearer now.
Yes.
No cross-examination on the reason that the judge relied upon. And it's the same, obviously, with respect to the saying he should have taken a signed blank transfer form. And that's why we say the evidence not having been challenged on the ground that the judge relied upon, the judge implicitly, therefore, rejects the challenge that was put forward in cross-examination, rightly so, because that challenge wasn't on the basis of the evidence actually given. The judge's rejection of it has got to be itself rejected because it wasn't the subject of cross-examination. Therefore, it's simply left with the evidence standing.
Can you give us a reference to the document which has been quoted at paragraph 31?
I don't have that to hand, my Lord. I'm sorry.
Is it in the bundle at all, do you know?
Sorry, my Lord.
Is it in the bundle?
I'm sure it is. The feasibility study, thank you very much, I'm told is at, in bundle 14 at page 11.
Page 2550, my Lord.
Sorry?
2550, it's...
Thank you, that's fine.
Do we know if this document was referred to in the written evidence of any of the parties?
Sorry, my Lord, I can revert to you on that one.
Of course, I mean, there's no hurry.
My Lord, if my submissions are finally being sufficiently clear to understand, I could deal with perhaps the three counter notices quite quickly. The first counter notice was seeking to rely upon estoppel, because your lordships will appreciate that Mr. Justice Bannister took the view that the estoppel was a nonsense. She was relying on her alleged ownership before the transfer. It was therefore illogical, as we've seen in any case, there was no evidence of any reliance, so it was a non-starter. The second counter notice is that which sought to rely upon an explanation put forward by Mr. Ung subsequently in Macau proceedings that was inconsistent with the explanation based on the Calcutta Strip project. It was an explanation that was in the context of financial difficulties. And we set out more fully our objections to it, but fundamentally, we would submit it can't be accepted into evidence because it didn't go to anything that was an issue at the trial. Now, I've made my submissions as to why it was agreed that the transfer was not a dispositive document, but there certainly wasn't any case pleaded to the effect that he had transferred away the beneficial interest because of financial difficulties. That's a positive case. It needed to be pleaded, and it wasn't, and therefore the statement that was made subsequently didn't go to anything at issue in the trial.
In a way, you say it focuses an interesting sideline on your main argument.
Yes.
Demonstrates the point.
Yes.
Yeah, I see.
And then the final third counter notice is in respect of the document from the relevant department that says neither Madam Chen nor Mr. Ung contacted them with respect to the Kotai strip project, but that is entirely consistent with Mr. Ung's evidence. Mr. Ung didn't contact them because he was leaving it to Madam Chen to be the figurehead, and he specifically says he doesn't think Madam Chen did what she said she'd do, and she hadn't contacted them. So it's exactly in accordance with his evidence. It's also evidence that they could have obtained for themselves.
In a way, this is all totally irrelevant, isn't it? I mean, if the judge was entitled to reach the conclusion that he did, then subject to your points, which we were touching on in paragraph 30 to 33, he reached that conclusion, and you don't need all this additional, or rather Mr. MacDonald doesn't need all this additional evidence. Alternatively, he wasn't entitled to reach that conclusion, in which case you can look at all the additional evidence in the world, but it doesn't help, because he wasn't entitled to reach that conclusion.
Quite so. We make the point that at the end of the day, the question as to why Mr. Ung executed that transfer document was only relevant to the court's assessment as to the position before the 4th of October.
Yeah.
As part of the story, he says, well, I had the beneficial interest, which is in dispute, and this is the reason why I then signed the instrument of transfer. But it's only a story that's relevant to the position pre the transfer. That's its significance. My Lord, I'm greatly obliged.
Thank you very much indeed. Thank you. Anything else? Miss Lord. Miss MacDonald.
Well, just a few observations on those submissions. My learned friend constantly reiterates that it was common ground that the transfer was not a dispositive document. In our submission, that's nonsense. Nobody denied that the transfer disposed of the legal title to the shares. So it was a dispositive document in that sense.
In a sense, all this argument about is it dispositive, the beneficial interest, etc., I mean, the guts really of Mr. Parker's argument is this was simply unfair. The judge adopted an assessment of the case which nobody put to him, and it was part of nobody's case overall, and was never put to Mr. Ung. And one can get into arguments about dispositive and so on, but that's the essence of his case.
It was put to Mr. Ung that the transfer was not for the purposes of the Kotai strip project, but was probably something to do with the fact that he was on the point of financial collapse, which was established by 10 pages or so of cross-examination on the agreements with the banks of June 2011, which I went through with him in tedious detail because there were 3 of them, and we got him to admit that he had bound himself in June 2011, 3 months before these documents, to pay very substantial monthly installments to the bank, but had never paid any of them, and that he'd been given until the January after the trial, which...
That was to explain the transfer of the legal interest, wasn't it?
The point we made against you is that the one thing everyone was agreed on was, that, or the one thing nobody was saying, was that this arrangement, which on its face appeared to transfer something of great value, namely the shares, didn't really transfer anything of great value.
No, nobody was...
On your case, you already had the essential value in the shares. This was merely giving effect, transferring the legal estate to where the beneficial interest was. On his case, it was a temporary dodge for whatever reason, but you were not going to keep the shares. And the one thing nobody was saying was that there was an intention to give the shares or sell the shares or dispose of the real value of the shares in that document. And he never had a chance to deal with that.
It was quite clear that Madame Chen's case was that the whole title, in the Westdeutscher Landsbanker sense that Lord Sumption's referred to, the whole title was vested in her after the 4th of...
Because it always had been, and that was disbelieved.
Yes,
That's
but
the trouble.
The legal title was vested in her because the shares were transferred to her, and on the very same day the directors resolved to register it, and the share certificate was issued. And of course, there was no question of the beneficial title not going with it because she already had it. That was her case. Yeah. So it was quite clear that her case was that as from the 4th of October 20...
If she'd advanced a case to the effect that the beneficial title been transferred at the same time, she would have been cross-examined uphill and down dale as to the inconsistency with her primary case, wouldn't she?
Well, absolutely, yes. So
Well, you seem to have avoided that fate, but have you been fair to the other side?
There's no unfairness to the other side if the pleading says further or alternatively there was an estoppel by convention in respect of these documents which were relied on subsequently as having the consequence that Mr. had nothing whatever to do by June and July 2012.
Well, the reliance can't be effective, because if she knew that, or that the beneficial interest had never belonged to her, and it wasn't intended to pass on the 4th of October, she didn't have anything to rely on. She would be dishonest if she put forward...
She was disbelieved when she said, I always regarded these shares as mine from 1996 onwards. That was disbelieved. But she wasn't... There was no... It wasn't put to her that she... didn't believe that they were her shares after the 4th of October.
Did she say she believed, even, did she say, if they weren't mine, contrary to what I believed, then I believed that were my shares as a result of the transfer? She never said that. Did she?
Because she only thought the transfer made sense because of...
Yeah, she couldn't have said
something she couldn't have believed in.
Yeah, well, no, she was in the position that she had put forward a very elaborate case which had been completely rejected. But one thing that did not mean was that the parties were... there was common ground between the parties as to the nature of the or effect of the documents of the 4th of October. There was no common ground at all. She said these documents were perfecting my legal title to property, which had been mine for the last 15 years. He said that these documents transferred legal title to you for a limited purpose, and you promised to give them back in 6 months, but didn't. So they were completely at odds about it. There was no unfairness.
So the judge found there was an intention on his part to give and on her part to receive something which neither of them agreed was the case.
The judge derived that, as he made it crystal clear, from the terms of the document.
Oh, yes.
He said, Mr. is bound by the documents he signed on the 4th of October. And the justification for that conclusion has been laid down by the board 3 years ago in the prime site case. He was bound by them because they both entered into those ostensibly contractual documents.
Where do we find that pleaded?
On the agreed, I beg your pardon, Lord?
Where do we find that pleaded?
Paragraph 9, subparagraphs Q and R. The only difference is that it's pleaded as an estoppel by convention, which depended on reliance, and my submission is, notwithstanding the point your lordship put to me, my submission is that she clearly relied on them. She undertook financial responsibility for the hotel. She wrote, I'd better show this to you, Lordships. She wrote to the bank on the 3rd of July, I think. I'll find that.
To rely on them, she's got to believe that
Yes.
they transferred
Exactly.
beneficial ownership in circumstances where the judges found that she did not believe that she had it beforehand and it was a pack of lies.
Yeah, but that doesn't
Well,
stop her believing that he's transferred it to her on the 4th of October.
Except
which
that
is
she
what
never,
the
she never,
documents-
she never said she did. How can you find an estoppel on a belief as to which there's no
Those are
evidence?
stopped by the documents which they signed on the reasoning.
Well, I know,
in
but
the
you
prime-
say it's an estoppel by reliance, and we're just probing the reliance.
Yes.
The reliance aspect depends upon a state of mind, an honest state of mind. And I mean, if you were advancing some other form of estoppel, it'd be different perhaps, but not on the basis of reliance.
My Lord, the fact that she was wrong and was found to have lied about her belief that the shares were beneficially hers down to the 4th of October, in other words, before they were transferred to her, doesn't make her belief that they were at any rate hers after the transfer in any way dishonest.
Where do we find that belief? Where do we find evidence of that belief that I own the shares
She-
as a result of the transfer?
Her case was these are my shares beneficially, and they have been my shares beneficially since 1996.
Exactly.
And they were transferred to me legally on the 4th of October 2011. Now, the judge disbelieves that they were her shares beneficially before the 4th of October 2011. That doesn't mean that he that doesn't mean that he should have concluded she didn't believe they were hers after.
But she doesn't say she believed that they were hers as a result of the transfer.
No, she says she believed they were hers for the reasons which she gave.
How can she say she relied on the transfer?
She doesn't need to say she relied on the transfer under the contractual estoppel in which the board has laid down in Lavarello.
That's the point being made by Lord Mance. You don't need reliance if your contractual estoppel is right.
Yes, exactly.
So we don't need to worry about
Exactly, my lord. And don't forget, number one in Meraki, Mrs. Meraki's position was actually these were mine all the time anyway, but that was brushed aside. And my lord, for a clear decision that reliance isn't required for contractual estoppel, see the next case in Bundle 24, the ANZ case.
New Zealand.
It's PK.
Find it.
It's 4855.
Looking for my marked up
Yes,
copy, my lord, if your lordships would bear with
Australia
me.
and New Zealand, yeah.
It's Springwell against AP Morgan Chase. And it's Bundle 24, tab 3. Paragraphs 177 to 178 at page 4932 of this bundle. It effectively rejected Mr. Brindle's argument that there's no juristic concept of contractual estoppel, which is distinct from the doctrine of estoppel by convention. That's now been confirmed by the Privy Council in Navarello. To my mind, once it's accepted there's a separate doctrine of contractual estoppel, there's no room for a requirement that the party which wishes to rely on that estoppel must demonstrate that it would be unconscionable for the other party to resile from the conventional state of affairs the parties have assumed. Reason why that's a requirement in the case of estoppel by convention is precisely because there's no contract between the parties. Therefore, some other mechanism has to come into play to make the non-contractual convention enforceable.
So this is a doctrine which is not dependent on
Sorry,
fairness
Mark?
or equity. This is a doctrine which is not dependent on fairness or unconscionability.
Or, yes, which includes, of course, reliance.
Okay, is that a convenient moment? Is that a convenient moment? Is that a convenient moment?
That would be a convenient moment.
Good.
So,
We'll resume again at 10:30 tomorrow. Thank you.